Hello, and welcome to the Magistrate Court Mediation Workshop, an orientation for parties, presented by the New Mexico Administrative Office of the Courts. If you are watching this video, it is most likely because your case has been referred to the Magistrate Court Mediation Program, which is a service provided by the New Mexico courts at no cost to you. You are required to attend the mediation session, which will be conducted remotely by video using the internet or by telephone. You should have received a notice of mediation session from the court that includes the date and time of your mediation. If you have questions about the technology necessary for mediation, how mediation works, or you cannot attend at the specified time, please contact the Magistrate Court Mediation Program as soon as possible by calling 505-750-0321. The goals of this workshop are to discuss what is mediation, to help you prepare for your mediation session, the role of the mediator, your role in the mediation, confidentiality, what does an agreement mean for your case, and what happens next. Mediation is an informal process that provides an opportunity for you to discuss your dispute with the other person or party to see if all of you can reach a solution yourselves rather than having the judge decide how to solve it. Sessions are on average 1 to 2 hours, but your session may require less or more time. Mediation is an opportunity for people who are in conflict to restructure their differences in an effort to find common ground and brainstorm possible solutions. Once in front of a judge, parties may no longer maintain that freedom and will have to live with what the judge decides to do. Having direct, meaningful communication will help, with the help of a mediator, about the issues at hand, allows for you and the other party to be committed to solutions you yourselves create. During the mediation, neither party will be forced to agree to anything they are not comfortable with. You are not required to compromise, although sometimes mediated agreements will include compromises offered by one or both parties. It will be helpful if you are prepared to answer questions about what you are willing to do to resolve this case and to reach a mutually acceptable agreement. Parties usually find dispute resolution more useful when they are prepared and have a plan. Your mediation plan should identify your goals, the other party's goals if you know them, and how you may be able to propose a solution that will resolve your case if possible. You should think about what you want to discuss and what's important to you. Thinking through these things in advance will help you and the other party negotiate a solution that is sensible, realistic, and fair to everyone. Mediators are trained to offer assistance in making the discussion as productive as possible so that you and the other party can make the best decisions for yourselves. Mediators will not make suggestions or give advice. The role of the mediator is to help the parties develop a satisfactory and realistic resolution to your dispute through communication and problem solving. The mediator does not provide legal services or advice. The mediator is not a judge or an arbitrator. The parties are responsible for making their own decisions. No one will be forced to agree to anything they are not comfortable with. Each party must be willing to fully participate in the process, that is, to talk and to listen. This is your opportunity to bring up all the issues you think are necessary to completely resolve the case. Mediation works best if only the parties involved in the dispute are present during the mediation session. Others may attend only if their roles are clarified in advance and only if it is acceptable to both parties and the mediator. This can be discussed with everyone at the beginning of the mediation session. You should find somewhere private for the session and not allow others to listen in or overhear your conversation. Also, no one is allowed to record the mediation session. The mediation session discussion is private and confidential. Only those directly involved in the dispute will attend the mediation. Attorneys may choose whether or not to attend with their clients. Mediation is a private and confidential process. The mediator will not reveal what is said in the mediation session except as required by law. For example, to report suspected child or elder abuse, or threat of physical harm, or threat of damage to property. The parties agree that the mediator will not be called to testify should future judicial proceedings occur in this case. The parties agree not to contact the mediator outside the mediation process. If your case goes back to court, the judge will not allow you to bring up what was discussed in the mediation session due to these confidentiality rules. If your case does not resolve in mediation, a trial date will be set. Even if you do not resolve your case in mediation, the process provides you the opportunity to share information, identify areas of agreement and disagreement, and to be more prepared to proceed to trial. If an agreement is reached in mediation, the mediator will prepare something called a mediation settlement agreement during the session, and the parties will be given the opportunity to review and sign the agreement. The agreement will be considered a legally binding and enforceable agreement. The mediation program will file the settlement agreement with the court unless you decide to keep the agreement private, in which case each party is responsible for keeping a copy of the agreement. If an agreement is reached, the parties will also sign something called a stipulation of dismissal. The mediation program will file the dismissal with the court and the case will be closed. If the mediated settlement agreement is not fulfilled or breached, the breaching party may, within 5 years of the date on which the stipulation of dismissal was filed with the court, file a motion for judgment. If such a motion is filed with the court, the case will be reopened and the breaching party has 15 days to respond to the motion and request a hearing so the matter can be heard by the judge. If the judge decides that the agreement was breached, the judge may grant appropriate relief, including entering a judgment against the party who breached the agreement. You will sign into your mediation session using the web link provided by the court in the notice of mediation session. If you do not have access to the internet and a device that has a camera and a microphone, you can call into the phone number on the notice as well. We ask that you sign in or call about 5 minutes before your session starts to make sure everything is working properly and that the session starts on time. It is very important that you sign in or call on the day and time on your notice. If you are not able to do so, please call the mediation program at 505-750-0321 as soon as you can. Please have ready any documents, statements, photos, or invoices related to or support your case so that you can discuss them at the mediation session. It is not necessary to bring witnesses to the mediation session. Because the session is confidential, please ensure that only the parties involved in the case are present in the room. For questions or for more information, you can send an email to magistratemediation@gmail.com or call 505-750-0321. You may also visit the web address that is on the screen for additional information. Thank you for listening, and we wish you good luck on your upcoming mediation session.